listening to Driving Law, a podcast by Kyla about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla at Acumen Law, and with me, my co-host, Doroshenko.
Good to see you, Kyla.
Yeah, you look like you're on vacation.
I'm hardly on vacation. I drove yesterday, left at 5:30 in the morning. Drove into deep in the interior to deliver alcohol to all of our client liquor stores. I managed to make it to Invermere last night by about 9 o'clock. Made my last delivery at after 8 o'clock. I had 2 donuts to eat during the entire day. And today I had a cup of coffee this morning, and I did not have time to stop and eat anywhere until tonight at 8 o'clock. That's all I had. Driving around working. And you've been working hard too. You've conducted 7 hearings today.
Yeah, well, it's not just that. It's not just 7 hearings today, right? Everything picked up after the tentative deal was reached on the weekend. Everything picked up on Monday. They were contacting our office to schedule hearings again for all the ones that had been adjourned where, there was already disclosure and already, the hearings were set to go. So all of a sudden I had, 17 clients who were going to have hearings in the next, 20 clients who were going to have hearings in the next 3 days that we need to be updated on all of that. And then at the same time, trying to prepare for a voir dire continuation on a serious trial. 5 hearings on Tuesday, voir dire continuation and traffic court on Wednesday, 7 hearings today, 8 hearings tomorrow. Plus I had my CBC today. So I literally had no more than 30 minutes in between every single thing. And that was only long enough for me to figure out what I was doing next.
So basically you haven't stopped talking all day.
Yeah.
And now you have to do the podcast. Should we just do a silent podcast?
Feel like it. My throat is sore and I gotta talk all day tomorrow.
My throat's sore too. I thought I was coming down to the cold and I thought, oh my gosh, how am I going to manage this 12 hours or 14 hours of driving, whatever it was. I drove from Vancouver to Kelowna. I was in Kelowna by 9:30 in the morning. Yesterday morning, I drove around, made all the deliveries in Kelowna. Terrifying because I'm driving this van and, over the Okanagan connector is a frightening spot to drive in winter. I've driven that a few times this year, and I've seen now a total of 6 vehicles turned over in the ditch on the connector. And this last trip, there was somebody who had a classic 80s Chevy truck or late 70s Chevy truck, and it was overturned attached to a trailer. So it was somebody who found a truck that they were transporting home on a trailer, and the trailer was flipped over with the truck underneath it on the connector, on the Okanagan connector.
All right. Well, maybe that's your ridiculous driver. I don't know.
No, I think there's a few ridiculous drivers we saw there.
Anyway, I want to talk more about the government getting things back up and running.
Let's do that.
So it's been insane. Like, they're scheduling hearings at all hours of the day, giving counsel barely any time to, even take a breath. Like, the idea that on Monday they're calling and wanting to book 5 hearings for Tuesday is insane. That is insane. And it's not fair. It's not fair to the lawyers to have to suddenly drop everything and remember what's going on in these files, every single one of these files that you were cognitively prepared to, argue over a month ago. And now remember all of them. Plus, now you're getting disclosure on all of the other files that you filed in the meantime. You have to call those clients to talk to them about their disclosure, prepare all of their evidence in their cases. In the 30 minutes you have in between hearings, you have to somehow figure out how to do all of this.
Not just that, we normally book the hearings 10 days in advance.
Yeah.
So having them 3 days in advance.
It wasn't even 3. It was a day. It was the very next day that I was asked to do 5 hearings.
Yeah. Call those people who are self-represented. Let them do their hearings the next day.
It's
That's just individuals.
And, it's the end isn't in sight. The end is this is the beginning. This isn't the end. I'm looking at the week of Remembrance Day, when I was thinking, oh, I didn't have any court that week. I'd taken some time off for vacation originally. I thought, oh, I was going to have a nice little time. There's a midweek holiday. I'll take it easy. No. Nope. It's fully booked up now.
Yep. Well, blame those people who were fighting for higher wages.
No, blame the government for failing to adequately address an access to justice issue while their employees were on strike because the government refused to pay them fairly.
Well, that's actually the number one issue is ultimately in the end, by the sounds of it, the government basically capitulated to the union. So why did it take this in order to get them to capitulate to the union?
Yeah.
Like if all they were going to do is just go along with the union's demand in the end and accept the union's demand or something very close to it, why did they force us in this situation of this strike? And not just form the agreement earlier? Because think of what it costs all of those companies. I mean, the restaurants, the bars. Okay, for us owning the distillery, we got to, we've expanded our business markedly and we've got all of these new clients and customers and everything. And that's great. But for all those restaurants and bars and private liquor stores that lost sales, had sales because there was, other stuff. But then think of all those other industries too. Like you're waiting for permits or something like that. You're waiting for the government to get back to you on some issue and everything is put on hold. It's just the damage to the economy of a labor action like that is, I mean, it's consequential.
It just also feels like the exempt staff weren't really doing anything. And I'm sure they were doing things, but they weren't doing the right things. And now it's even worse, Paul. It's even worse. You don't even know any of this because you haven't been around, but they're not allowing us to get the disclosure on the files we filed for review back in September, beginning of October, back in over the last 30, 45 days. They won't give us the police reports until we now schedule the hearing. Despite the fact that our clients have paid the $200 and have been entitled to this disclosure all along, they're like, no, you have to schedule the hearing date first, which means you don't even have an idea of how much work you're going to need to do to build in your buffer time. You just have to guess and hope.
Oh, we got to write a letter to them about that. That's bullshit. The people that paid for their hearing, they should get their disclosure when they paid for the hearing. Just because they didn't have it ready is not an excuse.
Yeah. Yeah. And so now, it's a gamble, right? You're gambling on who can you schedule to get the police report, and is it going to be, an insane amount of work?
And I bet there's a bunch that there's no police report for because they never asked for it, despite the fact that we filed, right?
Don't know. Don't have any way of knowing until we set a date. But then we set a date for somebody if it was not properly sworn, or there was no report submitted, or there was some other fatal flaw. We've booked up a time in our calendar when we're already booking 7 to 8 hearings a day.
It's just every day we deal with the IRP scheme, and every day it just feels like the furthest thing from justice you could possibly imagine. And those judges who have upheld so many aspects of the scheme over the years, if only they knew,
Yeah.
this is the way it played out.
And then
I hope one of them gets an IRP so they can discover it. But
I had one adjudicator today tell me that, he doesn't know, but he thinks that because everything is, catch up time and being uploaded now, that RoadSafetyBC, normally what would happen if there was a report that's not properly sworn or it's not submitted in 7 days or whatever, there are managers who follow up on that, right? They double check, they do the revocation, it all happens very quickly, usually. But because of the backlog, the idea, it seems to be, is that the files are just going to be assigned to adjudicators and proceed to hearing anyway.
oh, what a waste of time.
Waste of my time, a waste of their time, and then because you don't know that they're taking the position it's not properly sworn or revoking it, you're preparing everything.
Or some other reason, yeah, you're preparing everything, and then on top of that, they're taking an adjudicator out who could be conducting a hearing for one that's got, issues that are in the case, not issues with respect to jurisdiction or legality of it being before the tribunal.
staff in our office spending time doing, interviews, drafting affidavits, corresponding with the clients, me talking to the clients about all this type of stuff, telling them what they need to get, following up with them on all the things. So our support staff following up on the clients to submit everything. Like it's intense resources to prepare one IRP and to force people to prepare IRPs that should have been revoked without a hearing, and in fact, by legislation, should be revoked without a hearing. That's bullshit.
Yeah. Well, I mean, we won't even get the disclosure. We get the disclosure
We don't even get disclosure to know. It's
know,
wrong. Anyway,
after we've scheduled the hearing.
so this is the current, cognitive situation I'm in. And
So none of this is contemplated in the Motor Vehicle Act, and they're just doing it ad hoc. And they've been doing it ad hoc in a manner that has fundamentally denied people's rights under the Motor Vehicle Act.
yes. So right now, for the week of November 10th, we have 15 hearings scheduled, for which we've only just received disclosure.
Gosh.
And I'm told by our assistant who does the scheduling that he's aiming to set 45 in that week.
45?
Double booking us for 9 to 3 every day.
Oh my gosh.
Yep.
So there was a lot of IRPs issued in October. Because it goes back to September. Oh yeah, I guess it does. First, yeah,
Remember?
yeah, that's when the first ones. So still, that's a lot. That's a lot of IRPs plus the new ones coming in.
Yeah, plus the new ones coming in that still have to be scheduled. And
Oh shit! Well, we're gonna pull everybody out of the distillery off the bottling line.
and they're not scheduling
Just the IRP assistants.
they're not scheduling dates for the new ones that we're going to file because they're trying to deal with the older ones first. So it's literally exactly as we predicted, snowballing it. As we head into
This is gonna go into the new year. We're gonna be Christmas ones are not gonna be conducted until February.
and what's the busiest month of the year every year for IRPs? Christmas month.
Isn't it July?
That's December. December and August.
Yeah.
Yeah. But
Well,
December.
So the labor dispute ultimately caused us to suffer, or our clients.
Yeah.
But we have no choice.
Now I'm making that argument in every single case. I am, arguing that this is a violation of our clients' charter rights to have a reasonable hearing, a reasonable opportunity to challenge the apparent results of the ASD, that the reasonableness aspect of that Section 8 protected right relates to the timeliness of the review as much as it does to have any right to review it on the basis of anything else. So, like, I'm making that argument. I'm making the argument that the procedural fairness rights have been violated because people haven't had the right to be heard on the fact that they weren't allowed to schedule hearing dates or that their hearing dates were unilaterally adjourned. The procedural fairness rights under the doctrine of legitimate expectation being violated because people have, based on the statutory structure and the historical practices of the tribunal, a legitimate expectation that when they file their application for review, they are to be provided with disclosure and they are to schedule a hearing date, and their hearing date is going to be typically within 14 days of the date they received the prohibition and the decision within 21 days pursuant to legislation. That's their legitimate expectation, and it's completely thrown out the window. And then, of course, you have this other question of whether the superintendent even retains jurisdiction over the matters if they don't schedule a hearing, considering the fact that in order to dispute it, you must file the application for review in the correct form, and the correct form requires you to put a date and time.
For the hearing.
Yeah.
Yeah. Also, where's the authorization or jurisdiction to adjourn a hearing? They can adjourn a decision. They can give themselves an extension on time for a decision, but there doesn't seem to be any authorization for them to adjourn a hearing for a labor dispute.
Well, also, they can only give themselves an extension if you read the Motor Vehicle Act, Section 215.5 sub 7, which is the section that gives them the authority to extend the time to render a decision, is in a section 215.5 that's titled in the marginal note as decision of the superintendent after a review under Section 215.
Exactly.
Right. And the review hasn't taken place, yet they're already rendering decisions that are supposed to only be after the review. And to make matters worse, there's also this huge natural justice breach because, of course, he who hears it must decide it. But the people who decided already made decisions affecting our clients' rights to extend the time to render a decision are not the people who are now conducting the review hearings. So you have multiple decision makers on the same issue.
They had an easy option. You know, they could have just revoked the prohibitions for people.
Could have done that.
Just accept the fact that you're not going to be able to uphold them anymore because you don't have the apparatus to conduct the hearings, and recognize that and revoke the prohibitions. It's a short period of time. Revoke the prohibitions.
Yep.
It's a labor dispute. Labor disputes have consequences. The government has to face the consequences. Revoke the fucking prohibitions.
Yep. Anyway, sorry. That's my rant.
Good rant. Solid.
So that's what I've been dealing with. And of course, in every hearing, to make the whole cognitive thing worse for me, in every single hearing, I've been arguing all of those things I just said now. But of course, you only get 30 minutes. And I especially can only use 30 minutes because I've got, another hearing and another hearing and another hearing. So I can't go over just because I won't have time to go over, even if they would let me go over. I've got to use some of that time to make all of these procedural fairness, charter, and natural justice arguments and statutory interpretation arguments, plus all of the substantive arguments for all of these people. So I'm squeezing in twice the legal arguments into the same amount of time than what would have happened in September had the hearings proceeded as expected.
So this nightmare starts for me on Monday, where I will start doing 7 hearings a day too, I guess. My question is, how do you feel about having been off, not doing this for a few weeks? I mean, you made arguments in court, very impressive, substantive arguments, but IRP arguments, I mean, one of the things that I've noticed, doing it, a few days a week and having, for my second hearing every day, I always know I'm really tight. And I get to the point where I know I'm really tight, but I know if I don't have a hearing for a week for a vacation or something like that, I have skills atrophy. So how do you feel about having a month of no hearings?
I'll tell you, this is like the Dodgers and why the Dodgers are going to lose the World Series. Because they had a week off. They swept their league, and they had a week off before the World Series games started. The Jays went to Game 7. They played up until like 2 days before the World Series games started. They kept their skills going, and it's actually true in baseball for batters. I'm learning all sorts of baseball stuff. I know you're looking at me like my baseball facts are suddenly. But
Well, I don't want to think this way. I mean, I want to get my skills back fast.
well, I mean, I'm glad that I have been throughout this in the middle of a serious trial that has had a lot of legal issues come up suddenly and unexpectedly, unusual legal issues, we'll say. And so I have been keeping my argumentative skills up. But yeah,
You and I have been arguing about those issues
yeah. I
on
mean,
a daily basis, but I mean,
it,
kind of clear cut most of the arguments.
I'll tell you what, Tuesday I was asking the adjudicators afterwards. I was like, do I still know how to do this? Like, did I make any sense? Did you follow my argument? Because I don't know that I did.
I've asked that to some of the adjudicators over the years, and they, for the most part, said, no, that was good. You were right on. That was brilliant. And they've always said that you and I have particular skill with this. So, but we listen to each other's submissions because we're missing a portion of a wall about that wide that divides our office. People
I
don't know that.
I don't think I ever listened to yours because you're only ever making submissions if I'm already doing one.
Oh yeah, that's true. You haven't heard mine. There's times you've come back from court and things like that, and I'm in the middle of it.
Yeah, that's fair. I've heard portions of it. Your
Yeah.
style and my style are very different.
No, I know. You just focus on the law, and I focus on pointing out why the facts are absurd.
Anyway, so that's all that's going on. And yes, you are correct. How is it trying to do it again? It's like it's like riding a bicycle in that people tell you you'll just pick it up again, but no, there is a relearning curve there.
Mm.
And, thankfully I had 5 hearings thrown right into the fire on the first day that we started doing hearings again. So
Well, there you go.
back back to normal now. One of the adjudicators today commented to me. She's like, "Did you get faster?" Because I talk really fast.
I know you talk really fast.
I got the
It
loop.
complained about me talking fast, and I've heard yours, and you are speaking much more quickly than I ever do.
Yeah, and yes, I did get faster. Because I have more to say in a short time. All right.
Somebody once commented somewhere on the internet about us, said, "Oh, they use AI," and we don't use any AI for any of that. But can you imagine AI trying to make those submissions that we make,
Yeah.
try and pick up those subtleties and try and explain those things?
In fact, I can imagine AI doing it because sometimes some of my clients think it's very helpful to send me what ChatGPT told them I should say.
That's interesting because, yeah, I've noticed that we get people emailing us inquiries, and they're quite obviously Chat GPT written. And I keep thinking that I should just cut them and paste them into Chat GPT and say, "What is this person's main concern?" before I respond. Do I have to read all of this?
Mm. It's like we're such heavy users of ChatGPT, not for our legal work, but for other reasons. Like interpreting my dog's blood test results today.
Or me trying to like sort out car problems.
I've been relying on ChatGPT to learn a lot about baseball statistics and records.
I've been using it to calculate how much load I can put in our van.
Exactly. So we're heavy ChatGPT users for other reasons.
For
But
not legal reasons.
it becomes so obvious when you use it all the time when something's done by ChatGPT. And
Yeah.
so, yeah, like if you're a potential client out there and you think that you're assisting your lawyer by plugging your legal arguments into ChatGPT, you're actually, I'm sorry to say, and I don't want to be rude here, but you're kind of wasting your lawyer's time because then they have to turn around and explain to you why everything ChatGPT said is not actually legally accurate, which is what I have to spend my time doing now. I have to be like, "Oh, thank you. I don't want to
Yes.
say that you used AI, so I'll just address your concerns, but I know that you're just relying on something that doesn't understand."
Well, and that they don't understand that when they're sending it to you, they just think it sounds smart enough that I'll send it to the lawyer.
Sure.
Fair,
Sure.
fair.
Yeah. Okay. All right. Let's talk about some other driving law things. There is an update. Throat is so sore. There is an update on the Lapu-Lapu case. It's not a great update.
Now it's going to get bumped way down the road. That fellow's still in the psychiatric care, and the thousands and thousands of pages of disclosure. So it's just being basically adjourned. It was in front of Judge Reg Harris, and he said, "Well, I guess it's going to take some time. Thousands of pages of stuff."
That's an interesting issue, though, because, of course, a case is supposed to be resolved if it's in provincial court within 18 months of when the charges were approved. And charges on Lapu-Lapu were approved, most of them were approved, like, the day after. So you have already, it's been, when was that? Was that, like, May? It was before I moved.
Yeah, could have been. Yeah, I'm thinking back to when you moved. It was, yeah, just before you moved. So April or May.
Yeah, clock's ticking forward, and they've got thousands of pages of disclosure to review, that they're still getting, and the judge has adjourned this into January 2026. So, you know, time is slipping into the future. It's not gonna be a short trial. It's gonna be a 30-day trial probably, if it goes.
Yeah. Is it going to be a trial though, Kyla? Realistically,
I mean, it's a conviction. Well, no, I mean, he could still have NCRMD, right?
well, that seems to be what I would predict is the.
And then, if there's the dangerous driving causing death, if, there's probably some pineapple arguments to make. There's, issues with respect to the Crown's proof of intent. Did he just intend to drive badly or did he intend to kill?
There'll be some Asian voir dires on admissibility of something.
Yeah,
Always is.
statements, I'm sure. But still, I don't anticipate that trial being less than 30 days. If it goes to trial. And if there's not
No, I mean, it really depends on who the Crown decides to call. And they could probably pare it down quite a bit. And I'm sure they'd look for a lot of admissions.
I mean, I will say with Judge Harris as a case management judge, he'll be encouraging the parties to make as many admissions as possible.
Yeah. No, he's a smart and organized fellow. So.
Yeah, but still, I worry about Jordan on this. And then the question is, does it qualify as a complex case? On the one hand, yes, there's a lot of evidence, but that doesn't make a case complex just because it's voluminous. The Court of Appeal of Ontario has said that just because, the murderers have a ton of evidence, that doesn't make them complex. Complexity comes from like novel legal issues or things like that. This is somebody who drove a car into a crowd of people. It's actually factually quite straightforward.
If you're making admissions, you could drag that thing out to a 6-month trial.
And you could, and the court would not be able to fault you if you said, I'm going to hold the Crown to strict proof of every single fact in this case.
You could compel them to call every witness for which there was a statement.
Yep, you could. And then in that circumstance, you're doing your job to defend your client. It's actions taken to legitimately respond to the charge, even though it might not be the most efficient course of action. It's still your right. I don't know. Like, I think there's a very worrisome potential here that this thing is going to end up potentially being a Jordan argument.
I don't see it. I think they'll get it on. Although I see your point, I think they'll get it on.
I know the lawyers are not, they're not the lawyers to fuck around and try and make a Jordan argument where there isn't one. Some less scrupulous lawyers might take advantage of that situation, but I know the
all lawyers are scrupulous, Kyla.
I said less scrupulous.
All lawyers are scrupulous.
Some have more scruples than others.
Point is, sometimes one gets the sense of people trying to fabricate a delay. And one never knows what took place there. And I think there's probably been occasions where judges or prosecutors or whoever thought that I was trying to fabricate a delay. And I have specifically made it part of my career life to not fabricate a delay. And that is something that you do too. You work hard, so there's not a delay generated to create a delay to assist a client.
Okay, I was going to say, I'm unfortunately there is always a delay on my files, but that's just
There's always a delay because of legitimate things that you are arguing that you could change the law.
Yeah. Anyway, it'll be interesting to see how it plays out. And the last thing I'll say about the delay issue is remember that it's not just what the lawyers want and it's not just what the judge directs. At the end of the day, Mr. Lowe is the one who's in charge of the conduct of his defense. And if he instructs his lawyers, which he's been found capable to do, to make every possible argument, to examine every possible witness, to admit nothing, the lawyers act on those instructions, even if they would like to make the admissions.
In any event, I think this is a matter that's going to end up in BC Supreme Court. So I think it's going to be the 30-month window, not the 18-month window.
I am not so sure about that, but we'll see. We'll see.
Yeah.
So yeah, okay. What else did we have?
Those were, I think, our 2 topics. We had like 16 different ridiculous drivers of the week from which to choose.
Yeah, I mean,
it's your podcast, so you get to choose.
I guess the big one is Cowichan, which is actually been in the news a lot lately for other reasons. Cowichan Hospital in Duncan. Somebody drove a Chevrolet Traverse SUV through the front doors of the hospital. Which, like, if you're gonna crash your car, crash it into the hospital.
I suppose if you need medical care, I mean, maybe that's the reason to do it. We'll see whether or not we get any more information about it. But
well, what we know so far is that the car made it into the waiting room for the ER, and there was a 42-year-old woman who was allegedly driving the vehicle, arrested by the RCMP. But prior to her being arrested by the RCMP, two paramedics who were at the hospital went to try and help her because she just crashed her car into a hospital, and she allegedly assaulted them while they tried to help her. And then she was apprehended under the Mental Health Act.
Okay. Well, so there's an issue there. I was just thinking the waiting room is such an unpleasant place. I'd rather sit in my car.
Yeah. If only you could. You know, like when you go to a restaurant and they give you that little plastic buzzer thing, or the
Yeah.
text message when it's, your table's ready, please approach the host station within 10 minutes of this message. Why can't you
Yes.
sit at the hospital?
You could sit in your car. Well, the problem is in the hospital, you have to look really sick. Like you're in the waiting room doing your best to look pathetic in the hopes that that's going to speed up your response time and the triage of the ER.
Yeah, unfortunately, I think there's a lot of compassion fatigue on looking real pathetic. That's
I'm sure. I'm sure.
it's not gonna help you.
Show up with fake blood spraying all over the place. That's the only way you're going to get treated quickly.
Oh, I once got taken in, right away. Remember when my back gave out and I thought I was dying? I thought I had, my appendix burst.
How did we get you to the hospital that day?
Um, one of our assistants picked
Yeah.
me up off the ground because I collapsed in front of the office and wasn't able to move my legs, and, dragged me into the passenger seat of my car and drove me she was gonna drive me home, and then my mom's like, "You're having an appendix rupture," because all the symptoms were the same if
I visited you that day in the
Yeah,
hospital.
you weren't
God, that's like such ancient history now, huh?
you came to visit me in the hospital, and it was, like, super embarrassing for me because the, like, doctor was really hot, and she was mad at me for not wanting drugs, but I was like, "I have to go to court tomorrow." Did I go to court tomorrow? No. No, no, no.
I just remember it, um, that it was so long ago that it's all so vague.
Oh, I remember, you picked me up, you had to drive me home because I couldn't drive.
Yeah.
I could barely walk, and the doctor said, "You have to walk a circle around the ER, and if you can do that, you can leave." And you know what happens when somebody says, "I can get my way if I do one thing."
Yeah.
All of a sudden, I have the strength of 1,000 men. So I walked a circle around the ER. She said, "Okay, you're fine. Here's some, oxycodone. Have a nice day." I walked out the doors, then collapsed on a bench immediately outside the doors, and you had to wait with me on the bench until I was able to drag myself into a standing position again.
Then I put you on the bus, sent you home.
Exactly. Anyway, yeah, that was my hospital experience, thankfully not apprehended under the Mental Health Act. But
Could have been though.
that's how you get in fast. You show up to the triage station. I remember this so clearly. I'm like, I show up to the triage station and the nurse looks at me and she goes, "What's wrong with you?" It's like, that's not a good sign. What
I mean, can think about your work experiences in life. You took me to the ER once. I guess I've been to you with the ER once.
Mhm, mhm.
Yeah. Haven't take anybody else from the office to the ER.
Do you remember when I had to go to the ER when I had, like, a heart rate of, like, 176 during, one of my bouts of COVID? And, so I had to go to the ER. Yeah, 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 I had a, like,
Did
in
I take you?
no, 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 I drove myself.
Okay.
Again, probably shouldn't have. Could have had a heart attack at any moment. Like, immediately got the echocardiogram, but then they made me wait after that, and for a long time, they drew the blood, there was no elevated troponin, they're like, "Eh, she's not gonna have a heart attack." And then they made me wait, and Roy came into the ER with my laptop so I could work while I waited to be seen.
Oh, so Roy's been with you to the ER.
Yep.
Somebody else, I don't know who took you the first time, and I've been there. And you took me to the ER. So yeah,
Yep.
just a matter of time until we have to take some other people to the ER. Let's
Well,
knock on wood, knock on wood that won't happen.
ugh.
That's plastic. Okay, there's our podcast.
That's our podcast. If you have a driving law related question, please don't call, please. You won't get me. I'm in hearings. You won't get Paul. He'll be in hearings. Email. Find us online at vancouvercriminallaw.com or tune in next week if we have the capacity for another exciting episode of Driving Law.